session. It's an impromptu session, so if you're just joining, it's not as if we planned it ahead or made publicity behind your back. Because I like to carry everyone along on the channel, so it's an impromptu session, as most of my live sessions are. I just prefer it that way, just to maintain the originality of the discussions. I hope to hear from you in the comment section if you join while we are still talking, or if you watch the replay or restream later. So on this live session, we want to talk about a very important phenomenon in the Nigerian criminal justice system, or on the Nigerian criminal justice scene. And I am hoping that we are able to, start a very important conversation and edify one another. So you already know, if you're familiar with the channel, that I am an ex-prosecutor. That means that I used to be a prosecutor, and I'm still very much part of the criminal justice system, because now I'm back to the defense side. I used to be a defense lawyer, then I was a prosecutor, and then now I'm back on the defense side. And possibly I'm also doing some neo prosecution, different cases, no conflict of interest. That means that by virtue of my work now, uh, I am able to assist and help the prosecution in certain cases, with advices, prepping, and whatnot. So, but in my private practice, I am also a defense lawyer. So I wear so many hats. To Jesus be my glory. Today we want to talk about the phenomenon of complainants saying that they do not want to press charges, or they do not want to sue, or they do not want to continue with a criminal matter after a charge has been filed or a complaint has been filed. It's something that's very common, so I want to hear your opinion and I want to share mine. It's not something I picked sides on, because I think it can be variegated and multifaceted. So we can't say, oh, this is how it should be done. And from my little research, it is something that affects the whole world. So it's a global issue, a global phenomenon. So let's talk about it. If you have watched the video that I did about 4 years ago on how crimes are prosecuted, I will try to link it in the description box after this live session, so you would be able to well, you would be able to have an idea, a clearer idea of how crimes are prosecuted in Nigeria. But if I may, let me say that this is how crimes are prosecuted. When something happens, so crimes can be the prosecution will can be started by various means. Someone could file a complaint, that is the victim. If someone has been raped now and they head to the police station to file a complaint, they have kick-started the wheel of criminal prosecution. Police could be tipped, or they could gather information. So if maybe there has been an armed robbery somewhere now, and there's a radio the police station to say that, oh, an armed robbery is going on at so and so place, or maybe there's a criminal activity, maybe prostitution is going on in a certain brothel. So, and the prosecution is tipped, sorry, the police are tipped that, oh, this and this kind of unlawful illegal activity is going on in this brothel in this particular place, and then they could go make the investigations and then put a case file together, and then make arrests and charge people. The wheel of prosecution has been started. In some other cases too, it could be the government, or it could be the executive that may be interested in a matter of treason and treasonable felony. Now, it is already clear the acts that can lead to it, even though some acts are interpreted into the extreme to say that this is treason and treasonable felony, but no one will report treason or treasonable felony. No one will report or tip it. The government itself will kickstart that activity. So hi Dami, hello. So thank you for joining. So through the prosecution arm. So that's how crimes, the wheel of criminal justice can be started. So but in the general instance, what happens is that a crime is committed against someone, or an activity, an hurtful activity is committed against someone, they may not necessarily know what crime it is. Then they go report to the prosecuting authority, the police. Hello, Musa, Valerie, rather. Thank you for joining. So they go report, and then the police will make their investigations, make arrests, interview people, have people, suspects write their statements and the witnesses, possible witnesses, and then they file a complaint. But what usually happens along the line is that someone lays a complaint, and then when the matter gets serious and it's going to court, or when the matter is in court already, they turn around and say, I no do case, I no wan do again. They don't want the trial to continue because they don't want someone else to go to jail. It's usually for various reasons. It could be undue influence. I think you must have seen what has happened in the case of the Uber driver. If you're a Nigerian, or if you follow Nigerian news, the Uber driver that was allegedly assaulted, by a customer who happens to be a lawmaker as well, and who posted the video. The video was posted. Everyone saw what happened in that video, and then the lawmaker was charged to court, granted bail. So a criminal matter is ongoing in that instance. But recently, the Uber driver has come out to say is to apologize, for infuriating the lawmaker. So many things might have gone on behind the scene. We would not be the judge of that, but it could also come to a situation where he begins to say that as the nominal complainant, he no longer wishes to file a charge. He's a nominal complainant because his law firm has disengaged their services, and in the memo that they put out, which I read, they said that he walked into their law firm and briefed them to represent him. So a charge was filed. They petitioned the police, and the police put the case together. So this is the complainant here. So what we want to talk about is cases where the complainant withdraws and says they don't want to do a criminal matter again. They know they do case. So why does this happen? And what does the law, what's the proper position of law on things like this? So I'll start by saying that these things happen for so many reasons, because of the kind of society we live in. Our Nigerian society is still very much communal. Everyone knows everyone. So usually when things happen, when a crime is committed, you find out that the family of the suspect, they rally around them, and then they begin to look for how to get them out, by trying to, in some cases, beg the victim and the victim's family not to press charges, or where they have pressed charges, to withdraw the charges or withdraw themselves from the case, or not to give evidence against that suspect. And sometimes it turns out that people find out that they are connected, they are family members or distant relations, or they've done each other some good before, and now it's time to pay back the favor. In fact, it's very common in Nigeria for people to say that you don't go to court and come back as friends. That means that if you're taking someone to court, charge them or suit them, whether criminal or civil matter, you have drawn the line of enmity, which could go forever. So in most cases, people try to avoid court cases. But this is not to say Nigerians don't sue. As a matter of fact, Nigeria is one of the most litigious societies that I have practiced in. I've actually only practiced in Nigeria, so for context. But when you look at the docket of courts in Nigeria, civil cases, criminal cases, always packed full. So Nigerians are highly litigious. As much as we are communal and we always try to get cases out of court, we are also always getting cases into court. So, but what is the proper position where a victim or a nominal complainant? Nominal complainant just means the person that reports to the police, or the victim of the crime in most cases. So what happens when they say that they are no longer interested in the matter? The first thing is that they have a right, and they can exercise the right as they so please. So it is their right to decide that they do not want to press charges. But the state also has a duty to enforce law and to protect its citizens. So it is a matter of competing interests. their right as a person to do or not to do an act against the state's duty to protect and to enforce laws. So in most cases, there's usually an imbalance, which is why we're talking about this now. So, but the best thing is for us to achieve a balance. If someone says they are not doing case, it does not automatically mean that the case will come to an end. The first thing we'll consider is what is the right of the victim or the nominal complainant. Their right is to present them, to say that they want to press charges or not. It is also their right to present themselves for trial, as a witness or not. In the instance where they are a crucial witness and they have refused to present themselves, the court also has a right, and in some cases even a duty, to compel them. So that's when we talk about compellable witnesses. So if a witness is a compellable witness in a matter, the court can compel them to appear to give evidence. So the fact that they are exercising their right not to press charges or not to go on with the case does not mean that the case will come to an automatic end. What case can we think about? Let's think about murder, for instance. In most murder cases in Nigeria, people don't want to press charges because they believe that the life belongs to God, and that whatever the decision of the court cannot bring back the life of their loved one that is gone. Take, for instance, I was in a criminal matter once, and when I started calling witnesses, when the court had given us a date, and I started calling witnesses as the prosecutor, I called the mother of the victim, and she told me that I called her. I think I called her a few times, but the last time we spoke, she told me she's not coming. She has already told me initially that she's not interested. So she made a statement, do I want to continue reminding her of the death of her son? So I had to stop calling her. In that case, she has clearly evidenced a desire not to be a part of the case. But will the state let a murder slide because the one of the witnesses, or witnesses are generally said they are not doing? No, we can't. Now, in that particular case, what we will look at is the evidence that we have as the prosecution to support the case before the court, because prosecution will not go to court if the case will not be a success, because it will be an exercise in futility. So in that instance, the mother was not a very crucial witness because she was not at the scene of crime, but she knew her son had told her he was going somewhere, and then he had not shown up, and then they found him dead. So it wasn't as if whatever she had to say was so crucial that it would defeat the case. So we could not strike out the charge, or withdraw it rather, for the court to strike, or ask the court to strike it, or allow the court to strike it out because of our own withdrawal. I called the father too, indicated an interest to come, but let me know that he's a stepfather who married her mother much later after he had been born. And so, but he was ready, he stood in as a father for him, but he could not compel his wife to come, but he's willing to come. But, he also sounded like they had given everything to God. Religious leanings also affect how people hand things over to God in Nigeria. So it's good to hand things over to God, but where there's a procedure, a legal procedure for such a thing to be redressed, it is also good to explore it. So in this instance, what do you think should be the proper thing to do? I want this to be a very interactive session. I want to read your comments and continue to reply to them after the live session. So I'm going to leave a lot of things open-ended. So in this instance, what do you think would go on? So I put a few things down. I'm going to be looking at them, but we have generally talked about the victim's right. The victim has a right to press or not to press charges, actually. But note that that right is competing with the state's duty to protect not just the victim, but the entire citizenry. So we're looking at instances of, we're trying to make sure this does not happen to someone else. It's not even so much about you now. So if we do not prosecute, it will send a message that people can get away with this crime, and so we will see that the crime will go on the rise. It would also send a message to the victim, to the offender, that they will not be punished. So it will not only encourage the crime to continually be committed, but probably to be committed on a greater scale, on a larger scale. Also, it may send a message to the general public that they have no redress at law. So we cannot, because you say you're not prosecuting, or because you say you don't want to press charges, or you don't want to continue, we cannot say that you will not we will not prosecute the case. Now, when we look at the victim's right too, the victim is also entitled to protection. So what if the victim's life is in danger and they have absented themselves from court as a result? I was in a murder case, I've talked about it on the channel before, and it was two terrorist groups, not terrorists, cultists, two cult groups. A cult is a group, so two cults clashing, and then they had clashed. A man was building his property, and then some people came to him as omonile. They wanted him to pay them as the omoniles. In Nigeria, omonile is people who claim that they are the traditional owners of the land, ancestral owners of the land. So even if you have bought it, even if you have bought it from a private person, or from the government, or from an institution, an establishment, or a company, or a real estate company, for instance, they will still come, and some people will still come and say they are the traditional ancestral owners of the land, so you must pay them a due as you're building your house, and they will bill you whatever they please, and you have to pay. So in cases where people are unwilling to pay, they introduce force, to take money from people forcefully. So they had come to him, and as protection, he also recruited an opposing court group to protect him and his workers while working on the building. So the two court groups then clashed, and then they killed one of their leaders. The leader of the other court group also died in the process of arrest and prosecution. Died much later due to injuries sustained during clash, according to the file that was forwarded by the police. So now, when we open trial, of course, we have the investigating police officer, who is usually the star witness in many criminal cases, and very much so, because where a victim is refusing to give evidence, we might just have to fall back on the IPO and what the IPO has investigated, because they are investigating a professional capacity. So they escape the hearsay rule most times. So hearsay rule, I've done a video on that, so please look for it on the channel and watch. It just means that if you were not there, you heard it, they told you, the court will not treat your evidence with so much weight. It is not admissible generally, but even if it will be admitted, it will be with some conditions. So he said, I called him, he said that his life was in danger, he was being threatened, so he would not come. In that case, should his not coming put an end to the case? What if he was the star witness instead of the prosecution? Would that put an end to the case? There's a provision of law for witness protection. It is not so strong, or near inexistent. Is it inexistent or unexistent? Near non-existent in Nigeria. Witness protection means that if you're a state witness, the state has a duty to protect you. So there's usually, the modus operandi, already put together by the state. Maybe they put you in a safe house, make you incommunicado, and make sure that whoever can hurt or harm you while you're giving evidence on behalf of the state cannot reach you. So, but I've written an article on witness protection before. Please look through. You can just put witness protection, or I wrote it generally on prosecution in Nigeria. I'll link it in the description box so that you can easily read it. I'm very much invested in criminal justice as a lawyer. I've done a lot of research, written a lot, and I'm still doing more in criminal justice, both locally, domestically, and internationally. So, in domestic law and international law. That's what I mean. So, because now I'm also looking at international criminal law. I've done a thesis on conflict and warfare, and the duty to protect, responsibility to protect, and humanitarian intervention, and all of that. So, but today we're talking about a domestic situation where the victims say that they don't want to press charges. So now, he said his life is in danger. The next thing would have been for us to admit him into a witness protection program, but we did not have that while I was a prosecutor. So in most cases in Nigeria, it is not existent, or it is not so strong, if existent at all. So what happens in that situation? That is one thing that we also need to look at. What happens in that kind of situation? because we cannot afford the witness the protection they need. If they say they are not coming to court, they are right, because they cannot sacrifice their lives because in the process of getting them justice. That would be a Trojan victory, and it would be a great gift. So in that instance, what do you think should be the proper thing to do? Of course, we should strengthen our witness protection program, but where the victim's life is in danger, do you think or not that they have a right to abstain from litigation, to withdraw from supporting the case in court, or should it be pursuing justice at all costs? What do you think? So if you are on the session, please you can continue to feed me back in the comment section. Now we have talked about the victim's right. The next thing we want to talk about is the state's resources. Where a victim says that they are no longer interested, the state's resources can be tampered with, it could be wasted, because in some cases where the nominal complainant is the key witness and they are saying that I no do case, the state may not be able to sustain the charge. And to sustain the charge, the most important thing you need to do is prove the ingredients of the crime, that the defendant has actually committed them, fulfilled all the criteria for the commission of that crime. So if the person the crime was committed against is now absenting themselves from the case or court, or saying they are not interested, how do you prove it? In some cases, it may frustrate the entire case. That would mean that all the time, the man hours, the labor, and the commitment, the resources, everything that the state has put into getting that matter up to that stage has gone down the drain. We're talking about the time of the prosecution in investigating the matter, in taking witnesses and victim statements, in putting the case together, filing it in court, paying and all the resources involved, and even the prosecution being in court, their time that they are expending, which could have been used for other, fruitful businesses of the state, all of that will go down the drain if the case cannot be effectively prosecuted because the victim is withdrawing from the case. So that is one other thing we need to consider. Criminal matters waste a lot of state resources. It wastes the time of the court too, because the court could be on one criminal matter for 5-6 years, and at the end of the day, it turns out that the case is going to be thrown out, or the judgment is going to be against the prosecution, which is not a bad thing in itself, if not that it would be because of insufficient evidence or inability to prove the ingredients of the crime. It could also mean that a guilty defendant will go scot-free, because the court will rather set 99 guilty persons free than convict and sentence an innocent person. So evidence, supporting a criminal matter is very crucial. So where the evidence is not sufficient or not credible or tangible enough, it could defeat the entire case. So we need to look at that too. State resources going down the drain because people are withdrawing from criminal matters. They are saying they don't want to do case again. For instance, we once filed a charge of or I was once handed the file, because I wasn't the one that filed the charge. I was not handed the file. My team rather was once handed the file of that contained a charges of murder, attempted murder, unlawful possession of firearms, and I think one other charge. Now I called the witnesses. They said they were going to come to court. So I thought, oh, this is a clear-cut case. Witnesses are on ground. The accused person is in custody. We have a good case. Let's just open and shut it. When we got to court, surprisingly that day when I got to court, I met their lawyer, who then spoke to me, and then my witnesses that were coming to court, I met with them, and then it turned out that they were with the defendant's lawyer, and they were all telling us that they are family members. It was an accidental discharge, that the defendant was actually saluting his uncle when he shot the uncle in his leg, I think twice, that they were all members of, a vigilante group. So, to explain why they had guns and why they do gun salutes. So, their lawyer wanted me to withdraw the charge. But yeah, here's a consideration. I can't just withdraw a charge like that, because there's also contained in the charge unlawful possession of firearms. If we explain away the attempted murder and say that it's a mistake family are settled, everyone is at peace with each other, and the witnesses are consenting that the matter should be withdrawn actually. What do we do about unlawful possession of firearms? What will happen to my conscience as a prosecutor if tomorrow I hear that that same gun has now been used to kill a child or to kill an innocent person, or if later I find out that these people are actually criminals and not family members and they are touted? There's a marching band passing on the streets. Sorry about the noise if you can hear it. Today is Sunday, glory to Jesus. So what happens, if that firearm is used to commit another crime in the future, and lives that could have been protected by prosecuting this case to a finite point are now lost? So I told them I could not withdraw the charge. So the lawyer was not pleased. It was a very interesting situation. But that is what happens. So now, if you come and say that you're no longer interested, state resources that have pushed the matter up to this point, are you going to reimburse the state for that? You filed a complaint. This same uncle that was shot, I'm sorry, the uncle that was shot was not the one that filed the complaint. The father's the boy's father, the defendant's father, had filed the complaint, taking his own son to the police station to report him for firing uh, 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 a bullet at his uncle. But eventually they were saying it's as an accidental discharge, that they wanted to teach the boy a lesson and show that they are disciplinarians and they will not support rubbish. That's why they filed the complaint and all of that. But the police could have probably been putting out criminal fires in another portion of the state when they were busy attending to you, taking statements, and looking through this case. So most times people report in the heat of the moment, and then when things die down, they want the state to just follow them, like a sheep. If we say we are doing, you must do. If we say we are not doing, you must not do. You can't look at that. I put something down. uh, I put something down here. I want to talk about it. That's the potential for false accusations. Yes, this is another important thing we must look at. Now, if you are on the side of let's fire, if people say they are not doing again, let's just withdraw the charge. Or if you're on the side of whether they are doing or not, let's continue the case. In the midst of this is the possibility of false accusations. Sometimes someone could raise an alarm or report an issue of false rape, attempted rape, to the police. By the time, maybe the person has had a misunderstanding with the defendant or the suspect, by the time things calm down and they settle, they now own up and say, oh, it was false, I wanted to teach him a lesson. What do we do in that instance? So if we say that you must prosecute it to a finite end, at that point, we might not be able to prove the charge in the end, but that person would probably be in custody if it's a capital offense, and the person's life would have been destroyed to an extent, because most cases you don't go into jail and come back the same way, especially in Nigeria. And then the state's resources would have been wasted as well, and then there'll be a permanent dent that this is the person that wrongfully accused this person that destroyed their lives. Probably a family might have been scattered forever if they accused a husband falsely now of attempted rape or of rape. By the time the victim or the nominal complainant now says, oh, it was false, so if the state says no, we will see this to an end, at the end of that case, whether they convict or do not convict, that family might have disintegrated. The children might be gone, the spouse might be gone. So many things would have happened. Irreparable damage would have been done. So also, if the state would say that, oh, if you say that it's a wrongful allegation, we're not going to prosecute again, people cannot be left to just go like that, because that would mean that the state can be taken for granted, that you can raise a false alarm and then say cry wolf, like Peter, and then say, oh no, it's not like that again. So these are some of the issues. There was a time that I was handed the file of attempted rape. I didn't even remember it was attempted rape before I was giving this example. So I read the case file, it was clear cut, so I was I thought this was a straightforward case. Let's get it done with. So I started calling witnesses. Only for my supervisor or director of public prosecutions, then called me at the time. So, when we were going to court, I think I went to see him to say that, oh, court date has been set. Please help me call the investigating police officer. Sometimes if they do not answer on time, or if the time between which we need to go to court is so close, they might not yield to the usual letter writing. So if a superior officer can call them or call their own commanding officer to release them to court to come give evidence. So by the time I got to the director of prosecutions, he was telling me that the case has been sorted and it's no longer going to court. So the state will be withdrawing the charge because the girl who was the nominal complainant, the issue had been that she had complained. From the case file I read that, she wanted to rent an apartment, and then the agent that was showing her the apartment, or that gave her the apartment, I think she eventually rented it. Then the agent now tried to force himself into the house at a later time and tried to force himself on her. So eventually it turned out that they had just had a misunderstanding, probably an issue of rent or maybe agency fee or something. And then she just lied to the police. According to what the director told me, that the case has been, they sorted themselves at the police station. They went back to the police station to sort it. So it was now an exercise in futility if we were going to continue with the case. So the issue now is that, why did they not sort it at the first time when she complained and the man was arrested? Why allow it get to the Ministry of Justice, the Department of Public Prosecutions? Now about three state counsel or officers of the state, prosecutors, have had to sit down with that file, write legal advice, have it vetted by a superior officer, then have it approved or disapproved by the final superior officer before the charge was filed in court. It's a long process. Later, people will go on and say things in the society like, oh, Ministry of Justice, they don't file on time, they don't file charges on time. Legal advice takes ages to come out because some frivolous cases are sneaking in. And we work on the case file duplicated the to the state by the police. So if that's an instance. So if we're saying that if a victim withdraws, the case should die a natural death, it makes mockery of the state or the prosecution. If we're saying that the case should not die a natural death, it should be prosecuted to a finite point, what if it's a false accusation? Which would mean that at the end of the day, we may not be able to sustain it, or we may sustain it on false evidence put together, looking real, appearing real, and then we would have put away an innocent person or destroyed the life of an innocent person. So these are so many considerations that come up whenever we talk about, oh, if someone says they are not doing, should we go on, should we not go on? What are your thoughts? I put some other things down. Let me look through them. So when we look at those are I think that most of these things will fall into arguments for or against withdrawing a case where the nominal complainant has said they are not doing. Let's talk about deterrence. How do we plan to deter the commission of crimes if whenever a victim says they are no longer interested, we follow suit as prosecution? So put yourself in the shoes of the state. If you have made a law that stealing is a crime, and each time someone steals and you want to punish them, they come and say, oh, they begged me, I'm no longer doing, or they've given me back what they stole. There must be punishment for crimes committed. But the duty of the state would be not to destroy the offender, but to punish them uh, commensurately and to deter others from committing that crime. So it's very important. We need to look at this. We can't just let people close cases because a complainant is not interested. How do we deter the commission of crimes? By other people. For instance, in a rape case, or the rape of a minor, the defense counsel was telling the court that the victim and the victim's father had agreed with the defendant that they were no longer pursuing the case. and so the prosecution has no business continuing the matter. What happens in that kind of instance? Are we not sending a message to every rapist out there that if you can beg the victim's family, they will let you be let off the hook, the state will pause or withdraw the case against you? Because things like rape cause irreparable damage or loss. So begging cannot be the solution. In a matter of rape, in a matter of murder, begging cannot be the solution because it cannot bring back the life. In murder, in rape, it cannot heal the trauma, which sometimes could be for life. So we need to look at these things. Deterrence, very important. It's one of the reasons why crimes must be punished. Deterrence, very important, very, very important. There's another thing here, protection. Okay, I think I've talked about protection of the victim. Sometimes it could be due to duress, undue influence. If they are paid off, it's undue influence. If it's duress, it is also undue influence. Their lives could be in danger. They may be threatened. So if we say we are withdrawing the case because they are being threatened and saying that they don't want to continue the case, then the offender, the criminal, I'm trying not to use criminal because we've not reached conviction. The offender has won, and the state, the entire citizenry, and the victim have lost. So it's important. We cannot peg criminal justice to the whims and caprices of the offender or whatever agreement they reach with the victim. So criminal justice must transcend them. But while transcending them, we must also consider the things that I've mentioned earlier. We must consider not putting away an innocent person wrongfully, not destroying a life willingly or willfully, and not wasting the state's resources and the court's time as well. Time is also a resource. Now, another issue is that of public interest, which I've also mentioned. You know, we are not just protecting the victim by punishing crime or by prosecuting crime. We are protecting the entire citizenry to ensure this does not become our norm, that people will do things and go scot-free. So in cases where the public interest is affected, begging, reaching an agreement with the victim, or the victim willingly or unwillingly saying they are not interested in prosecuting, may not be the solution. It may not be the solution. It could be in some instances. I'll give an instance. In a situation where some people were robbed at some point, they were robbed. Students, their laptops were stolen and all of that. And then they came forward and the case went to court, and the defendants came forward and said that their families, of course, because they were in custody, came and said they are sorry, they are first-time offenders, and they will never do such again, that they are ready to pay up whatever has been stolen. They should just give, they will get the value and they'll pay it. They will reimburse the victims. So the victims were invited and they costed what was stolen, and the families paid it off. And so the case, eventually died a natural death along its way, because the victims did not present themselves to give evidence in court. So the evidence was very crucial in this instance because it was robbery on at close range. They were robbed, as students in their out of school hostels. Now there are two ways to look at this. The first way to look at it is this: where the defendants were sober, first time offenders, promised not to do it again, and restituted what was taken. What's your opinion on that? Is it okay for the state to have allowed the case die a natural death? Or, by dying a natural death, what I mean is that if the state keeps going to court and having the victims having settled with the defendants will not present themselves, the key witnesses in the matter will not present themselves, the IPO also would not present himself because he is aware that they have settled, and then in the absence of evidence and perpetual promise uh, to try to procure witnesses, not really procure witnesses, in the continuance of the state saying that their witnesses are not in court, yes, the court will throw out the matter. So what happens in that instance? Now that's one angle. The other angle is that if the victims have been traumatized, nothing can pay for the trauma. That's one thing. So how do you justify? These are competing interests too. How do you justify that? So it's very important for us to look at these things as a state or as a society. We cannot reach an agreement, and I hope we never do, that when the victim withdraws from the matter, it dies a natural death. There are so many cases that can proceed with the IPO, and we would reach, if a good conclusion, a just conclusion now. But in some instances, we must agree that whether the victim cooperates or not, justice must be done for the entire society, not just for the victim. In cases of capital offenses, rape, murder, cases where a life is destroyed in part or completely, the state must not agree to withdraw. The state must not agree to withdraw. So the state must continue to administer justice, because it's a position of trust. The state must continue to administer justice. So these are some of the considerations that I've been looking at. In some instances, in most instances, this is what happens when the victim says that they're no longer coming to court, or they are no longer interested in the case. They are asked to file an affidavit, with the state, with the prosecution, to say, we at the director of public prosecutions, to say that they are no longer interested in the matter and they would like to withdraw. So they file that affidavit, and that affidavit is also put before the court. So the court will look at the merits of the affidavits, to look at what has happened in this case. Why are they withdrawing? Is it okay? In some cases, the court itself will strike out the matter, having read the content of the affidavit and weighed it against, the facts of the case. So in some cases too, it could be to save the time of the court, so that the court can attend to some other important cases and cases that will be going on, so that the wheel of justice can continue moving. So the court also would agree in some cases, but in some instances, the court will not agree, and rightly so, because we cannot peg justice, like I said, to the whims and caprices of the victim. So we're looking at we've looked at the right of the victim to continue a matter or not. We've looked at cases of false accusations, or mistaken accusations too. That could come up where there's been a mistaken accusation. If, for instance, someone has gone to complain that their neighbor is the one that stole so and so from them, and they realize much later that it is not their neighbor, and they make the state understand that, what should the state do? There was an instance of someone who assaulted a neighbor, and the neighbor had to be admitted at the hospital. So she filed an affidavit saying that she was sorry. She had been made to pay the hospital bills of the neighbor, and she was remorseful for what she had done. And she would continue to ensure that the neighbor continues to receive good treatment and be responsible for the payment. So in that instance, should the case against them be withdrawn or not? I don't want to give definite answers, because I want you to look at these things from different angles, and I hope that we're able to generate a very robust conversation out of this. But these are some of the things that happen every day. It happens all over the world, all over the world. But essentially, if you have taken anything from this session, you should know that the state will not automatically withdraw in all cases, because the victim is recanting. That is one. Two is that the state will not continue in all cases despite the victim's recanting. There are so many things that will be looked at, and these interests will continue to compete. So let's have your opinion, and I'll see you in my very next video. Thank you for joining. Don't forget to subscribe. Toodles.